Hi, everyone. Welcome to Pro Opinion, where professionals share their opinions. We're talking raw knowledge and real expertise. I'm Diane.
I'm Professor Mel.
And we are back to talking about criminal justice today with our topic of pretrial detention and correction reforms. Right. We are thrilled to be joined today by a corrections expert, Dr. Raymund Narag. Dr. Narag specializes in correctional administration, prison governance, and pretrial detention. He's a respected and sought-after expert on corrections, especially in the context of the Philippines. He is an associate professor of criminology and criminal justice in the School of Justice and Public Safety at Southern Illinois University. Dr. Narag, thank you for joining us today.
Thank you also for the opportunity to be with your program, and I hope to share meaningful discussions as well. Thank you.
Awesome. Well, let's get started. You might have seen in the news that a man in Ohio was wrongfully imprisoned for 21 years and actually won a $1.3 million settlement from the state for a crime that, before being imprisoned for a crime that he did not commit. And in fact, there's doubt now on whether it actually happened. It's a pretty interesting story. But this person, 49-year-old Ralph Blaine Smith, and was first imprisoned when he was 24 for an alleged armed home invasion and robbery. And I'm just kind of wondering, with this types of wrongful convictions, and what do you make of this, and how does this happen?
Yeah, so those are really very unfortunate events that happens in the American criminal justice system. There are estimates that suggest that around 2% of the cases are involved are what we call wrongful convictions, and it provides a lot of hardship to the families involved. It provides a lot of negative consequences to the specific individuals who have to undergo these wrongful convictions, losing jobs, losing their lives, losing the real important events that happens into their lives as well. But the good thing here is that in the United States, there are mechanisms for them to be at least compensated for the harms that are done to them. There's a mechanism where they could eventually seek redress to the wrongs done. They could apply for appeal and mechanisms for them to maximize so that their wrongful convictions could be reviewed. So that's a good thing, at least as a remedy. And many people have been victims of wrongful convictions, especially like what we have found in the Innocence Project, had been compensated by this. But still, it's a long way to go. The system is imperfect. There are errors in, say, police arrests, police investigations. There's also errors in how the prosecutors determine who should be charged. There are also errors in the mechanisms in which the jury would convict individuals. And there's also errors in how judges do the sentencing. But it's a work in progress. Then hopefully that through these mechanisms, there are ways that we could improve the system.
Let me ask you a question, Dr. Narag. How do you think we can avoid these so-called wrongful conviction? Is there any set of procedures or infrastructure so that we can minimize these kinds of issues?
That's a very interesting question, Mel, and there's no one foolproof answer to that because wrongful conviction is a product of multifaceted practices in our criminal justice system. So, for example, with the police, police of course are hope that they will be trained properly on the procedures of arrest and procedures of investigation. The police, of course, are trained that they should not be biased in incorporating non-legal factors into their decision-making process. And also the same way with the prosecutors and judges and other actors in our criminal justice system. However, as you know, these individuals are just human beings. They are also product of their environment. They are product of the things that they watch in the TV, products of the things that they experience on a day-to-day matter, right? And so some of these individuals, bring their biases in the system. Some of these individuals bring their preconceived notions in this system, such that when an incident happened, right, they might not have foolproof evidence on who are the people really involved in this, but because of their preconceived notions, they come up with certain conclusions. And this is when, some people of, vulnerable situations like people of color, people who are poor, people who are marginalized, they are the ones who are likely to be considered the likely suspects. And that's when errors could happen in our criminal justice system. And the proven solutions for this, of course, are more effective trainings, more effective ways that we could reduce the bias. Specifically like implicit bias. There are trainings right there, right now, that basically sensitizes individuals that when they do, investigation, they should be made aware that their implicit bias could come in. So it's a really work in progress. I do believe that the United States, for this reason, had improved leaps, improved through the years, but there are still some incidents that errors could happen.
Yeah, one of the things that the Innocence Project usually rely on to reverse convictions is the use of DNA, right? Or the use of technology. But that is being used in order to reverse convictions, right? In which case the damage has already been done for the particular individual. Do you see a point where this technology could be used pre-trial or even pre-conviction so that jury tampering issues is lessened, or shenanigans in the investigation process may be corrected, and therefore it will eliminate or at least minimize some of these wrongful convictions that's been happening? I realize that there will be too much reliance on the science instead of the soft technology right now that we have, such as argumentative skills, bringing about convincing the jury through persuasion. What do you think of that? Instead of using it at the back end, we should use it at the front end.
That is correct, Mel. And in fact, many of these studies right now do suggest that we should put these mechanisms in the front end to minimize the harms done for wrongful conviction. And there are efforts to do just about those things. The problem, however, is it will require, fundamental changes in our criminal justice processes. So, for example, the practices of jury, evaluation of evidence. Jury, of course, are still bound into hearing the testimonies of witnesses. Here, the juries are still bound on hearing what the police officers would have to say orally as part of the evidence, and that's the way it is in our, criminal justice processes. But if there's a way to overcome or overhaul the system, that there's a way for us to change the system a little bit so that these technologically driven evidence gathering mechanisms should be put in the forefront, I do believe that will, provide us with a headway on reducing these mechanisms of wrongful convictions. I perfectly agree with that solution.
Yeah, because I feel like there is a problem that we have with respect to people being unjustly punished in our system. But that's the reason why, personally, I also don't advocate for the death penalty, because especially of a permanent mistake that can happen
Mhm.
after the execution of a person, even if it's I think the estimate for wrongful convictions in the United States is 0.5% of all convictions. I believe that was a consistently found estimate in the studies. But still, when you have a permanent incapacitation such as the death penalty, any wrongful conviction is a very, very uh, tragic event.
Yeah, that's correct, because death penalty is irreversible,
Yes.
and you could not longer change the fact after it had happened. That's very correct.
Yeah. So aside from these so-called procedural changes that we need to have in order to introduce a new technology into minimizing this, do you see other mechanisms how we can eliminate uh, or eradicate or minimize wrongful conviction? Or if not, then is there a way we can reduce the damage that can be supposedly inflicted on a person who will be wrongfully convicted? And I'm thinking about some of the things that you're doing right now, such as, pretrial releases, or more, community-based corrections rather than incarceration, as a means to minimize the impact, just in case there is a wrongful conviction that can happen.
Yes, actually, the one that were mentioned by Diane a while ago was really an extreme example where people had stayed in prison for 21 years. But most of the more common incidents of wrongful conviction is when people have pled guilty for a lesser offense. They plea bargain simply because they want to be released, not because they really committed the crime, but because they want to just suffer, end the suffering of pretrial detention at the moment. And this situation happens especially in developing countries, and that's where my area of research is right now, in the Philippines, where we have noticed that many people have stayed in detention for sometimes 5 years, 10 years, and even 15 and 20 years. They are undergoing trial and never found convicted yet. And because of this, they would, be forced to plea bargain with the judge through, of course, the egging of the prosecutor. And we have noticed that many people have been transformed from prisoners who were never convicted to convicts who were never tried. And this is a phenomenon not happening only in the Philippines, but many countries in Southeast Asia and also in Africa that is struggling with prolonged trial detention and delay in the criminal justice proceedings. So, yeah, you're correct. One of the ways that we could address wrongful conviction is to make our litigation and pace of trial proceedings faster, so that people will not be induced to pleading guilty just because they want to be released from detention.
Now that you mentioned that phenomenon or fact about plea bargaining, then I'm beginning to think that we might have a greater number of people who are really wrongfully convicted, right? Just because they just want to get rid of the jeopardy of being punished
Mhm.
with higher penalty, they decided to just simply accept the fact that this is a lesser penalty, even if they didn't do it. But don't you think that's still a wrongful conviction, Dr. Narag?
Yeah, of course, definitely so, especially here in the United States, where 95% of all criminal procedures are disposed through plea bargaining.
Yeah.
And in fact, we have interviewed some people who plea bargained, and they are afraid to what a phenomenon called the punishment of litigation, where if you would undergo the criminal procedures and exercise your right to plead innocent or not guilty, and you want to undergo the full process, you are in fact given a longer sentence compared to individuals who just pled guilty of the offense. And so there's what we call penalty of litigation. The judges and prosecutors will mark you down when you exercise your right to a full-blown trial. And that's their message of saying, hey, we don't want this trial process to be observed. As much as possible, we are so-called efficient. We are going to dispose our cases as soon as possible. And that's our way for you guys to follow this culture that we have developed. And so indeed, yes, correct, Mel, that the practice of plea bargaining had, clocked or they have hidden the realities about wrongful convictions happening in the United States.
Yeah, that's really, really true. And this conversation is really, beaming a huge light of or sunlight into the shortcomings of the criminal justice system when it comes to providing justice. So, I think we need to do something with either that issue of plea bargaining and also the issue of using technology. But I'm not really sure how to proceed at this time. What do you think is a better alternative to address the plea bargaining phenomenon of just simply accepting a conviction?
Yeah, of course, the plea bargaining issue in the American criminal justice system had been it's a very, what you call this, well-guarded secret. Everybody is implementing it, but actually nobody is talking about it. Because on the other side, if you make all cases go through the normal process, they say, then the criminal justice system will just collapse, right? There will be not enough lawyers, there will be not enough judges, there will be not enough prosecutors to hear all these cases, should the accused exercise their constitutional right for a due process of a hearing. So that's what they say, that it's like a necessary evil in the American criminal justice system. On the other hand, there are now many states that have, reduced or curtailed the plea bargaining arrangements. So, for example, if you look at Alaska, they said that plea bargaining should no longer be allowed. But when they do that, they say that it also spawned, unique problems on its own. It will make the trial process even longer. It will make the pretrial detention even longer for some individuals. So they say that there's nothing wrong with plea bargaining as long as the prosecutors and the police do their job well. That when they arrest and they file cases against the accused, it's actually the accused who did the job, right? So there's what we call factual guilt in the first place. And since they are factually guilty, then when they plead guilty, and that's legally guilt, then there's similarity with the factual and the legal guilt. And as long as the police do their job well, then there should be okay. And so people are saying that we need to make our police even more efficient. there should be a police and prosecutor coordination right from the get-go, so that the chances of conviction legally and technically are higher. The other problem there, however, is that if you do that, then you need to have more police training, you need to have more higher police education, and that the police officers are truly knowledgeable of the things that they are doing. And so we need the resources for that. You need all the support for the police and for prosecution for that. So I do believe that there are efforts to do that, but still, of course, individual errors could come in. And again, it will go back to that big issue of wrongful convictions.
How about remedying it from the further end, which is reforming the penology or the penal system, where we probably have to remove some of the burdens of crimes, such as extra lengthy services or incarceration, or maybe even accessory penalties for that matter. Do you think those will work in addressing this issue?
Yes, of course.
Of course, the damage to somebody who's been wrongfully convicted.
Yes, this now forms part of the overall criminal justice reforms, where you want to make your criminal justice system more effective and efficient. And one way of doing that is through sentencing reforms, right? In sentencing reforms, you want to make sure that it's only the high-risk, violent offenders, especially the repeat offenders, who should be put in prison or in detention. And those first-time offenders, low-risk offenders, should be put in the community if at all possible. And detention will be used to them as a last resort. And the reason this is also very helpful in the long run is because you minimize the tendency for them to be, much more criminogenic, because prisons, as we all know, exposes individuals to the criminogenic environment, right? So you could be a first-time low-risk offenders, but then when you go into prisons, you are exposed to other more hardened criminals, and that's when you are exposed to more criminal lifestyle, criminal thinking, so that when you get released, you'll be more hardened criminal, right? And eventually, all of this leads to the illegitimacy of our criminal justice system, that our criminal justice system does not work, that our criminal justice system produces more problems than it is hoped to solve, right? So all of this now leads to we call it the second layer problem in the criminal justice system. And if you return it back to wrongful convictions, the issue of individuals who have stayed in prisons, they have been there for a long time, they get released, then they will be labeled as former prisoners, former criminals, former murderers. Then if they have those labels, then the system will consider them as such. And even if they will not be doing anything, even if they are innocent, but since they are the usual suspects, they are labeled as the primary targets for intervention, then they will be again reintroduced to our system. And so it leads to the problem of wrongful arrest, wrongful conviction, and problem that we have discussed earlier. So you are correct. Improving the entire criminal justice system will eventually redound to improvements in reduction in the wrongful conviction arena.